Esteemed participants of this very special webcast organized by the Board of Internal Audit and Management Accounting, we have here with us on your screens our Honorable Vice Chairman, or rather I can say the mentor of this board, CA Charanjot Singh Nandaji. We have CA Aarti Bansal, our very energetic and efficient secretary. We have Arun Agarwal, who is also working in the board. And above all, we have two very important personalities seated. One personality is more or less resembling me. That is CAK Vijay Srinivas. Your smile I meant, sir, nothing else. Your
Yeah,
smile and my smile are more or less one
very.
and the same.
I do
Yes,
smile at myself.
yes. Wonderful, wonderful, wonderful. In fact, esteemed friends, today's topic is very important topic. Uh, the new data protection bill. The new data protection bill, which has been recently introduced by and passed by the parliament. Now, what are all the opportunities for internal auditors? How it is going to affect the internal audit? What we can do, what we should not do. We have a very renowned speaker in CAK Vijay Srinivas, who hails from the historical city of Hyderabad in the southern region of India. And we also have a very young person, CA Siddhant Bora, who is going to moderate, who is going to. In fact, if you look at this, friends, CA Charanjot Singh Nanda, our very energetic guide, I can say mentor, vice chairman, whatever you can adjectives you can give. He has been selecting youngsters so that there can be a participation from them. They can learn this subject and improvise on them. So that way, I thank Nandaji for always guiding us. You have just come back from abroad and he still look at his face, is so energetic. Wonderful, sir. We all stand motivated by you. I welcome you. I also welcome CAK Vijay Srinivas. Sir, thank you very much
Thank you. Thank
for
you.
sparing your valuable time. In fact, I have noticed that it is only in this profession, the profession of chartered accountancy, that the word share is in its true sense is used. Sharing is caring, they say. So you have come to share your knowledge with all of us in a very new law. And CA Siddhant Bora, very young chartered accountant, very nice smiling face, and looks very brilliant on the screens also. Thank you for sparing your valuable time. In fact, you will be learning a lot today.
Thank you, sir.
Thank you, Aarti. You have been wonderful as always, being energetic and working for the welfare of this board. Friends, I would not stand between you and other speakers. I will immediately call our very energetic, the chairman of the digital board of ICAI, Nandaji, our vice chairman, and a very important person in the institute's council, a very important person in the institute's history of this council. And our Nandaji, sir, I request you to please address the audience and give your uh, opening remarks and also bless us all. Over to you, Nandaji.
Thanks, sir. Thanks a lot, my chairman, C.A. Rajinder Kumar P. An amazing personality that hails from Chennai, a man who is more popularly known as the GST man, putting his entire might and diet to create value and worth for chartered accountants. The speaker of the day, CA K. Vijay Srinivas, my very dear friend. Very interestingly, I met him and Mr. Premnath in Hyderabad on 7th and 8th of July. And thereafter, I was in Singapore when I gave a call to him. I said, you have to be speaker. His answer touched me. He said, I am always there for the cause of the institute. Whenever you call me, I am there. Madam Aarti Bansal, the secretary of the board, C.A. Siddhant Bora, technical support from Vinu, Arun Agarwal, and all who have come here to go home enlightened. Ladies and gentlemen, today's topic is a wonderful topic. Impact of new digital personal data protection law on internal audits. Very important. Whenever internal audit has to be thought of, data protection, data secrecy is a very important facet of it. You do so much work for international clients. And data privacy is something which will always put you at a parlous at a disadvantage if you are not moving in the right stage. Hacking of systems, data smuggling is something which has become very common now. And when you use technology at such great forums, you need to have controls, because I'm well appreciative of the fact that where controls go low, frauds go high. The Speaker of the day, Mr. C.A. Vijay Srinivas Kotapilli, who hails from Hyderabad, is a postgraduate in commerce and a fellow chartered accountant based out of Hyderabad, practicing over 21 years. He is also a CISA by ISACA, a certified fraud examiner by ACFE, USA, and an insolvency professional by IBBI. He has completed his advanced diploma in cybersecurity and data protection laws from prestigious Nalsar University, Hyderabad. He holds 8 post-qualification certification of ICI. Practically, he has done all the certifications. He is a member of 2 expert groups for proposed new syllabus of CA final in relation to technology and ethics. He is a continuing member of Hyderabad group of FRRG, formed by FRRB. And very importantly, he reviews various exposure drafts, including AQMM, recommendations of expert committee of company law, guidance note on audit of banks, peer review manual, etc. He is a public speaker on topics like bank audit, peer review, IT and IS audits, Excel, and data analytics. I have met him personally, and he's a man who understands things, and more importantly, his love for the profession always call upon newer professional opportunities for members in practice or in employment. When there are people like Mr. Vijay Srinivas, I don't want to waste even a single second. I withdraw and let Mr. Vijay Srinivas let him show his mettle and ensure that all of us go home enlightened, understanding his thought process. I would like to end by a simple couplet which says, "Gar खैरात में मिलती कामयाबी तो हर शख्स कामयाब होता है। अगर खैरात में मिलती कामयाबी तो हर शख्स कामयाब होता, फिर ना कदर होती हुनर की और ना ही कोई लाजवाब होता." I will give the English version, which means that if one could get competence in charity, then nobody would have appreciating the competence and outstanding nature of a person. When you have competent and outstanding faculties like CAK, Vijay Srinivas, the audience has to take benefit of it. Thank you. Thanks a lot.
Thank you so much, Nanda sir. Rightly said by you. It gives us immense pleasure to carry forward the legacy, the inspiration that you give us. On my side, I would like to welcome everyone, including our speaker, C.A. Vijay Srinivasan Kotapalli sir, and our Honorable Chairman, C.A. Rajendra Kumar sir, and Honorable Vice Chairman, C.A. Charanjit Singh Nanda sir. The topic for today that has been chosen is impact of new digital personal data protection law on internal audits. In recent times, we have seen the way of doing business and managing data has completely changed. There is no longer need to store data in physical form, and it can be easily saved on a computer or a server or even on the cloud network. With the development of artificial intelligence, management of data has become a very important tool in every business. It is also expected that in coming years, it will be the most valuable asset in the world, and might even be the reason for the upcoming war. On the other hand, with easy access to data available everywhere, the risk of data leakage and the wrongful utilization is also very high. There might have been instances we all might have faced where advertisements would pop up in our phones when you are just browsing through some website or social media about something you just discussed with someone, or you might have just scrolled through your shopping app, and once you would have liked the product and you would receive an advertisement of the same. This is because when we download the applications in our phones, we blindly accept the terms and conditions that allow the data sharing with the developer. Keeping this in mind, to safeguard the personal data, very recently the Digital Personal Data Protection Bill was introduced on 7th August 2023 in the Lok Sabha, which was passed by Rajya Sabha on 9th August 2023, and the Digital Personal Data Protection Act 2023 came into force on 11th August 2023. The prime focus of the act was to protect the rights of the individuals and data is used for the lawful purposes. What will this do is this will open up a new area of practice for chartered accountants to see how the data is maintained and work around the data. On the data owner's end, we'll have to verify whether the data stored on the cloud or a shared device or server, whether the access is limited or whether the editing and viewing rights to the data accessor is within the limits to avoid any nuisance or misuse of the data. We should really appreciate the vision of the Board of Internal Audit and Management Accountancy Committee and also the Institute of Chartered Accountants of India to organize this session within just 12 days of the act coming into force. And with this, I would like to welcome our learned esteemed faculty, CA Vijay Srinivas Kothabali, who has taken this the maiden effort for studying the act in very short period and also analyzes impact on way of doing internal audits. I hope this will definitely be a valuable interaction and guidance for all. Over to you, sir.
Thank you very much.
Thank you, Siddhartha. You have really summed up this, opened up very well, and you also got all the dates right. It signifies that you have done a proper homework for this session of yours. Wonderful. Yes, welcome, CA Vijay Srinivas Garu. Over to you.
Thank you very much, Rajendra Kumar sir, Honorable Chairman of Internal Audit and Management Accounting, and Vice Chairman, very dynamic, young, of course, in terms of thoughts and ideologies and innovative processes, what he builds in both DAB as well as this particular board. Very effective personality, which we have to learn a lot. And thank you very much for the board and Arts Bansali secretary for taking up this initiative. Last time when we met 2 months back, I think she was planning for this session, not exactly this topic, but she was promising for a very good session. And here we are. So without wasting much time, let's get into the topic. Let me start sharing my screen. Hope it's visible for all.
Yes, sir. Yes, sir.
So to start with, obviously, the disclaimer part is pretty much important because when we share our ideas, especially in the new act, it forms very important. It shouldn't be considered as a professional advice for that matter. None of the board should be held responsible for whatever opinion I share. And it also becomes important to have these kind of disclaimers for that matter conditions displayed properly by virtue of Section 6 of this Act, which says all the consents and all should be clear. It should not be like the way we read terms and conditions, ambiguity, tons of pages, wherein we just give our consent without going through that. It shouldn't be like that. The kind of provisions, what they made applicable in this Act has to be all the requirements of consent and all should be in a proper form. That's the reason I'm taking time to disclose this disclaimer to set an example of the Act, what we are going to take you through. Now, this is the where are the points, various points which I'm going to cover as part of today's session agenda. The phases of development. Of course, we need to understand the background of this thing because the journey when it started right from 2000, the IT Act. Later on, the kind of issues popped in by forming a committee or certain case studies, case laws, judgment given by Supreme Court, and also various developments what we have seen. Though there is a change in earlier draft versus the one what they have released. But still, it's always better to understand the background, which gives an idea about the basic preamble of this particular act. And I've also mentioned the structure and the various items important in terms of keeping the internal audit, or for that matter, audit as a perspective. So I'll not get into in-depth of technical aspects of that, but wherever it is necessary, I'll definitely touch upon. Now, to start with the phases of development, as I was mentioning, IT Act 2000 is what it started off when it comes to taking care of information technology issues, when it comes to breaching or breach of data or information security, or all that aspects of defining who will be a data controller, who is the person responsible to take care of the data and all that. Meanwhile, we have a couple of sections which have come in between, like 65A and all, 43A, so and so. Later on, due to certain decisions, again, those sections might be repealed, but ultimately they have thrown up a very good idea about what exactly we are speaking about, especially the Article 21, which speaks about the fundamental right, privacy as a fundamental right. Now, central government has started on this data protection privacy framework in 2017, while they have formed this particular committee, expert committee in the chairmanship of Justice B.N. Sri Krishna. During the same month, it's a coincidence that during the same month, Supreme Court has given decision on a particular case filed by Justice K.S. Puttaswamy and others with regard to privacy, which was actually filed in year 2012, and the judgment has come coincidentally as in the same month, in the same year when this committee has formed, which runs into 547 pages. Any academic interest person can go through this. This very good learning in terms of understanding the fundamentals of privacy, which is covered into 7 parts, having 9 bench judgments, each of the judgments, and ultimately the last part summarizing all those judgments. And in 2018, the Personal Data Protection Committee has submitted unfortunately, due to COVID and all, that got delayed the way they have come back with their reports and all. And that's where in the year 2021, in December, they have come up with their findings along with the draft bill called Data Protection Bill, Draft Data Protection Bill 2021. But as there were many modifications suggested by the committee, even otherwise, the draft bill, what they have presented is many a times, especially with regard to a couple of important provisions, differing with earlier 2019. So Parliament has dropped or withdraw the proceedings with regard to the data protection bill, both the drafts. And in November 2022, the draft bill, which we are now seeing as an act, has been published for public feedback. Though many persons would have given feedback and all, though the details about those feedback, whatever it is they have received, whether it's considered to what extent and all, that is not made available. But we presume all the concerns have been addressed, taken care in this, wherein if you see the dates, 7th and 9th are the dates where respectively it has passed through Lok Sabha and Rajya Sabha, and ultimately on August 11th, we have this Digital Personal Data Protection Act published, Vice Gazette. So 2 dates we believe very important when it comes to this particular journey. One is the date when the judgment of Justice K.S. Puttaswamy has come. That is in the month of August 2017. And the one is this particular August where we have received this act. Okay. Now, I'll just provide the structure of this particular data. It is actually pretty simple, a pretty small act consisting of only 42 sections. Which again having around 9 chapters divided into various. But ultimately, if I have to give a gist of what exactly this particular act is about, it considers the obligations of data fiduciary, the rights and duties of data principal, and of course the financial penalties out of breach of rights and duties, or if any obligation is not complied with. Ultimately, this is what the entire act speaks about. But when we speak about simple acts, like whenever we speak about, for that matter, any act, we'll have 2 different kinds of acts. One act, which is much complicated, which says subject to, provided, keeps on interlinking between various provisions and all, which is not so easy for layman to understand, but very good for judicial pronouncements or, for that matter, professionals to take care of. And we have another side, another act, which is pretty simple in language, pretty plain, like any layman can understand. But when we have acts of such kind where it is simple and all, that throws a challenge both for the professional as well as for the judiciary, because there'll be something like in between lines or in between words. Though it looks like pretty simple, it's very difficult when it comes any litigation comes up, how they are going to interpret those simple words exactly matching with the requirement of the litigation. So that's the challenge this act is going to have, and that is where we'll see many kind of opportunities lining up for both chartered accountants as well as for the advocates in terms of the litigations, what it is going through. Of course, I'll be taking you through the opportunities available here. And just to give a summary of this principle, which is again published by MEIT, their website, it basically has around 7 principles. That is, principle of consented law, transparent use of personal data, and purpose of limitation, that is for what purpose the data has been taken for processing. We'll understand the terms, what exactly each processing and all is about, and how they can maintain the data accuracy, what is the reasonable time limit to store a data, and what are the safeguards they have to take care, and also how far who is accountable for what. It also throws up accountability on the person who is owning the data. That is, we call him as data principal. Okay. Now, to start with, as I said, I'll be taking you through the key terms or definitions which are used in Act. But before we get there, let's start with the starting para of the Gazette of this particular Act, which says an Act, that is this particular Act, is to provide for processing of digital personal data. That's fine. One aspect you need to remember is digital personal data, what they are speaking about through this Act, in a manner that recognizes both the right of individuals to protect their personal data, that is Article 21, and the need to process that personal data, that is the purpose of requiring that data by the person, we call him as a data fiduciary, who is requesting that particular data for the sake of process. So two aspects: one is the right of an individual to whom that particular data belongs to, and the need for a company or a data fiduciary for getting that, taking that particular data. Okay, and whatever is this, that should be for lawful purposes and for the matters connected therewith or incidental therewith. So it will be purely for any particular lawful purposes. And of course, it comes another second challenge. What we have in this Act is though it has been assented by President, it has become an Act, but still the date has to be notified. And the challenge what we are going to have in this is, they have mentioned in the Gazette or Act saying that there will be different dates for different provisions. Okay, and the provisions we have in terms of obligations, we have in terms of rights, we have in terms of schedule, in terms of penalties and all. So all these things, we might have different dates. So that also we need to make a point. And one thing I keep on recollecting whenever I go through this Act, as many times I go through this Act, is the one what we had in case of GST, the kind of Act what we had, and later on various amendments, modifications, or for that matter, updates happening through various notifications, circulars, day in, day out. I believe this is one such Act where we have to keep on updating ourselves by virtue of various notifications or circulars, what it is going to come out once the board is formed, which is obviously, in the words of Minister Ashwini Vaishnaw, they are already in the process of creating a board. Okay. And another thing about this particular Act also is the way it has come out of the hands of our Honorable Minister of MeIT, Ashwini Vaishnaw, who himself is a double master's and also an IAS. So that gives a kind of assurance saying that this Act is not going to be, it is going to be kind of a very good right for professionals. Okay. Now, let's get into the important definitions of this particular Act, starting with the consent manager. It's not that every company is going to have. It's only in terms of those specified fiduciaries, we call it specified data fiduciaries, where they might have to employ a consent manager. That means a person registered with the Data Protection Board of India. This is the board which is going to regulate this particular Act, who acts as a single point of contact to enable the data principle. So we'll see, once we get into the provision, we'll see what exactly is the role of consent manager. So as of now, we just keep him aside. Now, coming to the data, it means a representation of information, facts, concepts, opinions, or instructions in a manner suitable for communication, interpretation, or processing. Okay. Now, as I said, this Act is pretty simple, of 42, 3 pages of definition, or RD to end of pages of definition. If you keep on going through that, every time you go through, you come out with a couple of surprising interpretations of that particular definitions. And this is one such, which says no, processing by human beings or automated means. Okay. Coming to the next definition, data fiduciary. Now, this particular slide is pretty important for us to understand, especially those who haven't touched upon any data privacy subject so far. See, as far as if you can understand the terms used in this particular Act, so you will be good with a particular Act, or helping out your client in terms of advising what exactly is required, what is not required. Now, ultimately, data fiduciary in Act terms, if you say any person who alone or in conjunction with other persons determines the purpose and means of processing a personal data. So if I have to put in a simple term, the company which is having that particular data, so that is a data fiduciary. Like say, for example, if you're performing an audit of a client, the client, if he's having certain data, personal data, that he'll be considered as a data fiduciary in relation to such personal data in conjunction with other persons. Say if he has taken help of some other outsourcing entities or some other consultants or some other associate companies or subsidiaries in with regard to such particular data, then those will be in conjunction with other persons. So we call him as a joint data fiduciary. For easy sake of reference, we'll call him as a joint data fiduciary. Okay. So this is one important term, more and more frequently comes upon throughout the Act, and also for us very important because ultimately, in our words, he is nothing but a client who is handling the data, whom we are going to review or perform an audit. Now, data principal obviously is the owner of the data, that is who represents that particular data, means the individual to whom the personal data relates. Okay, so it's an identity. I mean, also if you go to the Act beginning or in terms of personal data, if you see the data about an individual who is identifiable by or in relation to such data. Okay, so that's the representation of particular data. It will be identified, person will be identified, individual will be identified based on that particular data, or data is related to that particular person. So that is where the personal data comes in. So ultimately, the owner of that personal data, that is the one who is owning that particular data, is a data principal. Okay, so simple terms, if I'm speaking about a company, so far as I mentioned, data fiduciary, the data with regard to whom the data fiduciary is maintaining, the owner of that particular data or the identity which represents that particular person is called a data principal. Now here in this case, if it is a child that is below 18 years, obviously the lawful guardian will be considered as a data principal. And if it is a person with a disability, the lawful guardian, in case of both these persons, it will be lawful guardian or the parent in case of children who will be considered as a data principal. So that means if I have to have a consent with regard to throw up a simple example, let's say we are having an educational institution which is promoting, say they got first rank, second rank, third rank, whatever it is that they're taking out the names, their pictures, displaying in a paper. So obviously they have to take consent of a parent or a lawful guardian because they are performing a personal data, they are processing that personal data. Now, what exactly is a data processor means? A person who processes personal data. Now, there is an interesting definition of process that in the next slide we'll see. But ultimately, the person who performs that particular process on data on behalf of the data fiduciary is called data processor. Okay. So these two, kindly keep in note, data fiduciary and data processor. Once we get along with the scope of internal audit, these two terms are going to be very key to understand what is the sensitive aspect I have to consider when I'm dealing with the DPDPA. Okay. So person, of course, it includes individual, HUF company, all that what we regularly come across in any act, AOP, BOI, in case of artificial decision not falling within above, every artificial decision not falling within the above definition. So that's a personal definition, pretty simple. Personal data, as I was referring when I was mentioning about data principle, means any data about an individual who is identifiable by or in relation to such data. It's a vice versa. Let's say, for example, if I say kvijayasrinivas@gmail.com, it is identified, or for that matter, any other number, if it is identified with me, then or that other number will be personal data. And if I'm identified with particular identity, saying that my name coming along with some identification, so that will be my personal data. So either as a alone single item or along with a combination of data which reflects the identity of a particular person will be considered as a personal data. So we'll come across many such examples in our day-to-day life. Let's say, for example, if I take up our today's session while you are registering, would have come across asking for a name, email ID, membership number, mobile number, so and so, so and so. So all these will be representing your personal data, because one is linked with other. Any of these items can be considered as a personal data. Okay. Now, personal data breach, and this is where the aspects of a couple of penalties comes into picture, not only in this act, also in the case of Information Technology Act. So means any authorized, unauthorized processing of personal data or accidental disclosure, acquisition, sharing, using, alteration, destruction, or loss is considered as a personal data breach with regard to the personal data. Okay. Now, coming to the interesting definition of processing, we use this particular term in a loose manner when we generally use processing as part of our regular activities, could be computer related or for that matter, any production related. But if you see, it doesn't just mean a phase of the entire process. It includes right from the beginning till the end. That means it includes operations such as collection, recording, organizing, structuring, storing, adoption, retrieving, using, alignment, sharing, disclosure, all. So that means an end-to-end journey of a particular data, all the phases of a particular data, right from the initiation till its end. That means till its erasure or destruction, that will be considered as a processing. So nothing is exempted when it comes to the processing of a particular data. It includes end-to-end phases of a data, right from starting its journey till its deletion. All that phases will be considered as a processing. So you can imagine any company, even if for a while, let's say they have conducted a particular event, a marathon, okay, and they said, okay, we are conducting this 10K marathon in particular location to promote their activity. So they published a link wherein they've asked for certain information. So right from that particular time, when someone punches in the data has started its processing till the marathon is completed, and at the end, probably they delete or store or whatever it is. So as long as it reaches its end of destruction, still it will be continuing as a processing, even in an idle stage, even if it is stored in an idle stage without making use of any further use out of the particular data. Still, it will be considered as a processing. Hope you got an example. Okay, though it is not in furtherance of business, all the terms what we come across in our regular acts, even if it is stored as an idle data, just one time an activity, which I don't have any usage down the lane, still, as long as the data is being carried with the consent or withdrawal or destruction, that will be considered as a processing. Now, interesting development out of this act is the using the term of she. Okay, they've intentionally used this particular term to what we call to consider equal gender equality through using in a parliamentary law. Okay, so she instead of he. This is for the first time any parliamentary lawmaking has used this term. Very good to have such kind of things happening in a lawmaking process. Okay. Now, before we get into the key provisions, so far we have dealt with the key terms. That is the particular slide where I mentioned about data fiduciary, data principal, and data processor, along with the processing aspect. Before we get there, let me take you back to the agenda and one particular slide I want to display before we go any further understanding. That is what I prepared it as need to know and mark the difference. Okay, what exactly? Now, this act, many times in the provisions of the act, it refers to various other laws, though specifically they have not mentioned except for Telephone Regulatory Authority and all. They haven't specifically mentioned, of course, a couple of changes in terms of 43A IT Act. Yeah, they have mentioned with regard to IT Act, but a couple of sections and acts we need to keep in mind as an internal auditor when I'm dealing with a particular audit, no matter whatever kind of audit. That is, these are the few sections, section 13, time and place of dispatch and receipt of electronic record. Why? Because if there is a litigation saying that you have not communicated any consent request form or you have accepted any consent, the proof will be either my email communication, which I have sent to a data principal saying that I request your consent or I received a consent. So that is one evidence, which of course 65B also consider a computer generated evidence, 65B of Indian Evidence Act 1872 considers as an evidence when it comes to computer generated. So these are the few sections. Of course, there are many sections, but when it comes to this particular, I could identify these four sections are pretty important. Unfortunately, 43A has been removed omitted by this particular act. Why I said unfortunately, because in relation to this section 43A, there were rules published in 2011, which specifically defined a couple of terms like sensitive personal data or a body corporate, couple of terms where they included, interestingly, individuals also as part of your body corporate. So, of course, still it's a good learning for any person who haven't come through this data protection or IT Act. Just visit this 43A and also rules are related to this IT rules of 2011. You'll have very good learning about understanding what exactly is this. It might be helpful even otherwise to understand a couple of provisions of this act when you try to compare with that particular. Okay, and that is one modification wherever that section has been referred throughout the IT Act that has been removed or omitted. Okay. Now, similar to that, apart from now that we are speaking about digital personal data, you might come across, you might get a doubt that what about non-digital, that is offline. Okay, like no, in GDPR, they mention about offline data also, which is not covered in PDA. It purely speaks about the digitized data. When you say digitized data, it's not that every data which is directly punched into digital, even if it is non-digitized form data, later has been converted into digital form, that also will be considered as your digital data. Okay, so these are the two aspects of this particular act. One is directly digitized data, or a data which has been later converted into digital form. Okay, so apart from that, now that we have other sections in IPC also, which is again Bharatiya Nyaya Sanhita is a new act what they have presented in the parliament. So this act also the other acts also deals with the respective offline when it comes to data breach or any hard disk theft and all. So those sections are very much applicable. When it comes to the digital aspect, this act prevails over other acts, especially when it comes to conflict of any particular provisions. This act will prevail over other laws. And also the appellate tribunal has been given tremendous powers. Also, the board has been given tremendous power over the judiciary when it comes to litigations coming out of this particular act. That's the one great development what we've seen in this particular act. And as I was mentioning, other acts like Copyright Act 1957 63B, that is about infringement of computer system and all, which is covered in Copyright Act, that also you need to have a glance. And Section 65B of Indian Evidence Act. Now, mark the difference. Earlier, we have seen, need to know why I said mark the differences. These terms were referred by a couple of professionals during a friendly discussion in a couple of seminars, saying that no, do not disturb. We have already in the TRI, or we have cyber security standards, cyber security framework, which already takes care of data protection at the higher level. Then what is that need of this particular, or what exactly is different from that? I thought maybe when a couple of professionals have this, let me also include that as part of my presentation. So DND is purely with regard to your mobile number that is registered with the TRI, where you can avoid a couple of unwanted calls or lodge a complaint if anyone bothering you through that particular mobile number. So it has a pretty specific use. It doesn't no way deal with your personal data, which this particular act refers to. And coming to the cybersecurity standards and framework, this again, as I mentioned, it's a set of measurable requirements that an organization, standards are basically a set of specific and measurable requirements that an organization must follow, basically to comply with the regulation and best practices. Framework, again, it covers the various components or domains of organization, which to improvise the particular security architecture of a particular entity. So ultimately, though we come across this data security, information security in standards like ISO 27001 or cybersecurity framework of NIST, there is a difference for the reason that these standards or framework are meant for safeguarding the assets in terms of data asset to protect from the breaches or specifically cyber attacks and all. So they have different types of what you call standard. I mean, the types of data, what they are defined depending on the sensitivity and value. As I was mentioning, critical data or sensitive data, so and so, especially when it comes to health records and all, we have those kind of things. So we need to keep that away in mind, or more so when we speak about data security. So though we have security personnel like CISO and all, still a data protection officer or so-called DPO, the role defined by this act, is very much important or required, because it not just deals about the data overall. Like if I have to compare with the GST or income tax, because that's where you can easily relate with. Where GST, we speak about the transaction level kind of what. So this is one such act where I need to monitor the transaction level of each transaction, identifying who is the data principal of that particular transaction, what is the process involved in it, I need to mark that, or probably have a cutoff date, so and so, depending on the consent. So I need to keep a separate track out of it. Also, apart from the challenges, the legal aspects coming out of this issue. So obviously, CISO technically to extent the framework is designed properly, whether it is implemented properly, reviewing or monitoring happening properly, all that aspects in terms of identifying and detecting and all that, that's fine. But when it comes to the data, especially personal data, it requires little more extended version of that. In fact, more sophisticated version and identifying, interpreting what are the personal identifier or personal data out of that particular data. How I need to take a consent, how I need to ensure that there is no litigation out of it. Okay, so that's the main difference. That's the reason I brought up this particular slide before I get along any further. Okay, now let's move on to the key provisions of the Act. As I was mentioning, it applies to processing of digital personal data where it is collected in India, especially in the digital form or in non-digital form and digitized subsequent. Okay, these are the two aspects with regard to the personal data. Personal data definition already we had. Okay, so you keep on linking up with any two fields what you come across. Let's say name and Aadhaar card. Okay, or name, mobile number, email ID. Wherever you have these, could be part of your vendor list or why I mentioned about vendor list, though it is exempted and all, but still there is a significance for us as an internal auditor. So keep this in mind. No matter whatever, just try to identify just for the sake of ease, what is personal data. You say, okay, name and identifier, which relates to that name, maybe Aadhaar card or PAN number kind of thing. You keep on trying to make that particular mark. Now, it applies to outside India if such processing is in connection with an goods or service, any activity related to offering of goods or services to data person principal within the territory of India. DP, when I use short form, it is data principal. That is the owner identified person identified with the particular data. Okay. At the same time, the section 3, which actually says the application and all, it also says it is not applicable if it is by an individual for personal or domestic purposes. Say, for example, I through WhatsApp, I received certain contact information through one of my friend for the sake of maybe providing certain help or probably whatever in terms of domestic purposes, not a professional kind of thing. As long as it is personal or domestic purposes, as an individual, I'm exempted. But once I get into a role which is not in the nature of personal domestic, and this is where I was saying about when an act is pretty simple like this, when litigation hits upon, it becomes so difficult to come out of in between lines or in between words to interpret what is domestic and what is personal, especially for a person like me, freelancer like me, who runs the office from home or whatever. It becomes very difficult while using the same WhatsApp instead of WhatsApp business and WhatsApp personal. I'm using the same media to communicate both professional and as well as domestic aspects. So it becomes very difficult to demark between what is individual and domestic and personal purposes. So that's a challenge what we are going to have. But as of now, it's not applicable if it is for personal or domestic purposes, or if it is publicly made available. We have our social media accounts like Instagram, Facebook, WhatsApp. Say, for example, you published your details in WhatsApp. You have your detail of mobile number. You have provided your website. You have provided your email ID. You have your picture all with the geographical location. Everything is mentioned in your social media. Then obviously it is you who made it publicly available. In that case, if someone trying to process that particular data, that will be exempted. So this is very important for us to identify what is the data. Obviously, you have all the security features available in your social media, which one to disable, which one to enable data. So ultimately, the responsibility is on us to see that what is publicly made available, so that later on, if I'm trying to file a complaint against data fiduciary, I need to have a proper backup saying that no, everything I've taken care in terms of provisions of this act, or for that matter, any other act. That also there is one section in terms of duties of data principal. But as of now, these are the two aspects which is exempting in terms of this particular section. Now, processing section 4, it says about processing of personal data of data principal is allowed as per the provisions of this act or for lawful purposes only, provided you have a consent of data principal. Okay. So one aspect is you need to have a consent. of data principle saying that, okay, you can have this particular data for the sake of process. When I say process, again, for storing, saving, sharing, publishing, or whatever it is, and it is for legitimate purposes. There is another section which speaks about legitimate purposes that we'll see. So for these two purposes, processing of personal data is allowed. Okay. So section 4, again, one of the important sections which you need to remember, having a consent and of course, legitimate purposes. Following this section, again, it speaks about the consent request and all. We'll see that. Okay. Now, every request, see here, if you just go through that, let me just read out the provision and I'll try to explain the importance of this section 5. Every request for consent of DP shall be made by a notice that can be in English or any language published in your constitution, those various languages published in constitution, to be given by the data fiduciary. That means data fiduciary, as I mentioned again, a company which is processing the data or retaining the particular data, has to give a request for consent. Okay. So what is that? Let's say, for example, I'm accepting certain data. As I said, let's take up an example of marathon activity conducted by a company to promote its product. Okay, 10K run kind of thing. So while I publish that, I need to request for a consent to that particular persons whoever is trying to enroll. Now, in that consent, why this request is they've made, and interestingly, this thing is some are more or less to certain extent similar to your GDPR, because no, it has to be specific, clear kind of terms what they've used in that. But otherwise, this consent has, unlike GDPR, it has made certain important content which has to be mandatorily provided in your request for consent. Now, what are those mandatory contents is, it should speak about personal data required from DP. That is, what is the data you require and what is the purpose for which such data is required. And if in case you want to withdraw, what is the manner or mechanism of withdrawing the consent? Or if in case you have come up with some issue, some complaint you have, to whom you have to report, that is the DPO, data protection officer, or if he is not complying with, how to reach data protection board to further raise your grievance. Okay, these are the 4 aspects which a request for consent of DP is. Okay, now such notice is required to be given for data existing with data fiduciary as on the date of commencement. Let's assume that government has notified a date saying that from 1st of September, sections chapter 2, all the sections of chapter 2, or that is obligations of data fiduciary, is applicable from 1st of September. That means as on 1st of September, whatever data I have with me as a data fiduciary, or for all those data principles, I need to send a request for consent saying that I request for your consent to process the data or whatever it is. Okay. It's secondary that if they haven't responded to that, obviously you can process the data without any issue unless they withdraw the consent. As long as there is no response or unless there is a consent to withdraw, till the time you can still continue. But ultimately, it's your responsibility as a data fiduciary to send a request for consent. So I've just tried to study the content of this, and I made a sample notice out of it saying that it might look like something like this. Of course, they might specify a different format kind of thing, or they might even go this. So just to say, I've made an illustrative consent request form. The kind of minute details what you need to cover in this consent form, that is, what is the information you require in the consent form, what is the information you are looking from data principle, that is so-called the data principle information, that is what are the information you're looking for as an indicative illustration I made it. And for what purpose you are looking for this personal data, that is what are the goods you're looking for or services you're looking for. Those 2 aspects you have to cover. Along with that, it also need to give the rights available for data principle in terms of what are the rights a data principle can have. So I can even provide saying that if in case any further information, you can go to this link. Further, anytime during the process of your government, if you have any complaints, who is the DPO to whom you have to approach? What are the contact details of DPO? If in case the complaint at DPO level fails, how you can approach data protection body, so and so, so and so. Okay, so it's not just I send a mail saying that request your consent for processing the data. No. Section has clearly mentioned, Section 5 has clearly mentioned what are the contents to be had in the consent request form. So this is where the professionals who are handling the assignments, or for that matter, internal auditor who is reviewing, let's say as on 1st of September, you are part of internal audit team. And as a scope speaks about, if you go to internal audit scope, it has many things, not just about data protection. It speaks about all the various reviews of regulatory information, all those your scope. So you need to see whether all these consents in terms of Section 13, what I was referring earlier, IT Act, whether that have been sent in a proper form. There is a proper acknowledgement with regard to the request for consent. When I say that, for each of the DP, each of the data, personal data, what you hold to that particular DP, whether that request for consent is made available or not. Okay. Now, Section 6 speaks about, Section 5 is basically to have a request for consent. And what exactly is the consent is nothing but Section 6 has provided that. It shall be free, specific, informed, unconditional, unambiguous, with a clear affirmative action. I can't just put a button, a check button or a radio button kind of option, or I can't just give dumps of pages saying that no, these are all you are giving a consent. No, unlike what we have in insurance or loan documents. No. It has to be clear. It has to be specific, and that is specific is for what purpose I'm taking your data for processing. It should be unconditional. It should be not. It should not be one way, saying that no, entire ownership, entire rights are with my company or the data fiduciary. No, it has to be unconditional. It has to be unambiguous, very clear, and it should be affirmative. Just like the kind of clauses what we have in a couple of legislation where you have to give an affirmative opinion. Likewise, the action also should be affirmative. And more importantly, that such consent, whatever it is there, shall signify an agreement. It should be in a form of an agreement, because ultimately that is a key document which allows or does not allow a data fiduciary to process a data. And also, it's a right of a data principal, whether if he has to go for a complaint and all, whether he has followed this particular provision, and whether he's gone through that particular consent properly. Very, very important section when it comes to cutoff date, and also in terms of the regular continuation of data processing. Okay. So it should be significant. This is where another opportunity we can think of, both for chartered accountants or for that matter who is for in practice of advocacy and all, to draft a proper consent form, to draft a proper request for consent form. When I say drafting, it's not in terms of document. It could be online. It could be a media through a app, or it could be media through WhatsApp or email. So various media is also there. So you have to address that and ensure that these contents are part of the particular consent. Okay. And the processing of her personal data for the specific purpose, and be limited to such personal data as is necessary for such specified purpose. Okay. So it can't be any other purpose. And they have given illustration, also interesting illustrations have been given in the act. You can go through those. Say, for example, if you're downloading an app, let's say an app which allows you to convert scanning a page into a PDF kind of thing. But it is asking for contact details. Mostly we'll give preferences in a mobile app saying that no, we give consent. Unless you give consent for all, it will not be installed kind of. But unlike that, here, if I'm performing an activity which is merely scanning a document, they might require at the most the location of these things to know where it is being scanned, who is the person who is scanning, what are the documents, or camera permission or audio permission, but it has no requirement for the contact details of my mobile. So that is one which is out of the scope. So that just because merely by taking a consent, by including that doesn't make a proper consent. Okay. So it is which is necessary for a specified purpose. Those will be only considered as a proper consent. Rest of all will not be forming part of consent, and very much you have a right to erase or for that matter go for litigation. Such consent may be given through consent manager. This, as I said, this is not for all. it's not mandatory saying that it has to be through consent manager. And this role of consent manager is an interesting one, which might come up as a very good what you call a facilitation business model. Yeah. So it might come up as a very good facilitation business model when it comes to consent manager. So entities might bid for this, where they'll be a facilitator to have a certain a portal through which I can manage my consent to withdraw or give consent or modify, append, or whatever it is there. It can be done through this consent manager, which again has to be notified the process of registering a consent manager by the board, that is Data Protection Board. Now, another important provision is Section 7. Data. This is the I sometimes feel very important when it comes to the role of an internal auditor. For the reason that once we get into that particular scope of internal audit, I'll explain again. But whatever a data fiduciary is performing, if I'm as an internal auditor, if I'm on the role, let's say I'm from the internal audit department of the company, or I'm an internal auditor of a holding company performing internal audit of my subsidiary company, where I'm in roles of internal audit of a holding company performing internal audit of a subsidiary company, or vice versa. So that means I am part of my the data fiduciary. That is, I'm holding a joint data fiduciary role. So in that case, all that obligations what we are reading through Section 7 also equally applies to us, and that's where we have to be very careful, seeing that whether we are meeting with these obligations. So Section 7, it says, of course, I've just given synopsis or summarized, try to summarize the act provisions of this particular section. So it speaks about the data voluntarily provided by DP. That means wherever the data has been voluntarily provided by data principal. Let's say, for example, I approach a particular maybe an event management company or sports company saying that, no, I have this particular event next week. You have to arrange for this, and this is the number of these are the details of the members, or for that matter, whatever it is. So there, when I'm giving that voluntarily, that's data fiduciary may personal process that personal data because that has been given voluntarily. Doesn't have to be through a consent. It doesn't have to accompany a consent. Okay. One more important of Section 5 I forgot to mention is Section 6 is any personal data has to have a request of consent form. Okay, so it has to prefix or probably go along with that request for consent form. So that is one important section as I referred earlier. Now coming to the for the purpose of availing benefits of government, these are the what you call various processes which is permitted under Section 7 without violating the consent details and all. So data voluntarily provided by DP for the purpose of availing benefits of government. And here I'll share one interesting snippet of the second clause. I was discussing with my colleague, my friend Premna sir. So Western, when it comes to, we have very good e-governance in place in India. We have many schemes running through e-governance portal, many benefit scheme, all those passing through e-governance, many activities, including our couple of grievance redressal system is also happening through e-governance portal. Unlike in the other parts of the world, like Western and all, they are struggling to integrate or trying to manage the data protection aspects with the governance, what they are going to. So that's the reason even you see a couple of things happening in offline or non-digitized form. Now, fortunately, or coincidence, or probably a smart move by delay in the process of adopting this data digital protection over a period of last 4 or 5 years is, during these 4 or 5 years, many schemes, many activities have been turned out or converted into a e-governance aspect. Okay, so that has become much easy now for the Act to include saying that, no, these are all exempted or these are all part of your automatic process. So there is no hindrance in covering the e-governance aspect with regard to this data protection. Assuming that if the earlier draft bill would have gone in the same manner what it was published, maybe the e-governance wouldn't have been such easy for the government to manage or convert, or for that matter implement, because every stage, right from collecting of data from the public or statistics purpose or any kind of things, everywhere they would have to comply with the provisions of the Act earlier Act I'm mentioning about. then see how I can give the better services. Now that majority of the aspects have been already taken care through e-governance, it's pretty easy through this particular act to see, okay, this is exempted, or for that matter, these are all not considered as personal data processing for the sake of provisions of this law. So that has been much easier, which otherwise we can see the kind of struggles what Western or European countries facing by virtue of GDP. Okay. Now, to fulfill the legal obligations or comply with the judgments, only in that case, obviously, the data fiduciary can process the personal data, especially if I'm speaking about artificial judiciary person. If the artificial judiciary person itself is a data fiduciary, if they come across any personal data, they can process by virtue of this section 7. For meeting medical emergency, if in case of medical emergency, they can, without consent, they can go ahead in processing the personal data. To ensure safety during disaster or breakdown of law, they have given the definition, what exactly the disaster in the act, you can go through that. And for the purposes of employment or for employer to comply, I've just shortened the entire clause of that. But if you see, it speaks about sedation or conspiracy kind of thing, or if by not processing that, the employer is going to fall into a liability kind of thing, or that's a responsibility what an employer need to have to see that the liability is on is with regard to that particular data that is being allowed. Okay. Now, so these are the various provisions of section 7. All these 7 are important. 6 are important, and especially the employment aspect, where you might come across an issue saying that if an employee is sharing the data for the sake of processing of EF or ESI or any such data, what does he have to follow the consent and all? No, by virtue of section 7, at least to the extent of employment, when it comes to complying with the law, any law for that matter, employer is free to process the personal data without following section 6. Now, examples of legitimate uses I've just mentioned: transactional data such as sales invoice, purchase invoice. A vendor might give his PAN number, GST number, address, mobile number, his also his address, and all that aspects in an invoice. So that might be that is a legitimate use only, obviously by virtue of data voluntarily provided by DP. And also employees' data required for processing a payroll, or as I was mentioning, these are all. But I've also mentioned a couple of issues, the challenges, which again requires little more clarity. Once the board forms, maybe they might come out with proper notifications in terms of a couple of issues what this section is dealing with, or otherwise other sections are dealing with. But as of now, if you have to interpret, providing additional services to the employees or consumers or customers, such as personal travel arrangements, which is not in terms of perquisite or a fringe benefit. In that case, how I deal with section 7, corporate events for business promotion, as I was mentioning about a marathon run, even booking on their behalf. Some events are being booked. Let's say in US, some event is happening and they're arranging travel to staff or family of staff, which again, it's not falling into any compliance of law, or for that matter, it's not any liability of the employer to mandate that kind of provisions. And we also come across entities providing facilities like filing of ITRs. Let's say in case they share this particular data with another data processor for filing of ITR. And they might also have counseling services. They might have health camps. In such scenario, which is not exactly attracting the provisions of employment or to comply with the law. In that scenario, how I need to address this? I mean, obviously, this might require consent. It may not be falling into that. And that's where we have to be very careful as an employer. Now, continuing with this section 8, this is the obligations of the fiduciary. And wherever you see shall, that means that's a mandatory obligation on part of the data fiduciary, which has to comply with. Okay. Now, shall comply with the act irrespective of any agreement. That means even if I have an agreement which is against the provisions of that, saying that no, I don't require, I'm giving consent to retain the data for a respective period kind of thing, or something which is not a legitimate kind of provision. If I'm giving some ambiguous kind of terms in my consent form, merely by having those terms in my agreement, or the DP himself has failed in the, providing the consent, or for that matter, certain duties, what is included in the DP, if he has failed out of that, that doesn't give data fiduciary a right saying that no, this is a failure of DP, not that the agreement is clearly understood by DP and signed by that. That's not an exemption for me not to comply with this act. Irrespective of whatever may be the agreement or failure on the part of DP, a fiduciary, data fiduciary is mandated to comply with this provision. Another aspect is, if in case I'm engaging, as I said, I might do my payroll processing to the outsider, or I might do my maybe security related aspects to other outsiders. I might maintain my cloud computing with other outsider, or whatever it may be. Even if I'm engaging, the person, as we were differing to the definition of data processor, that is the person who processes the data on behalf of the data fiduciary. If in case I'm appointing such data fiduciary on that particular behalf, I can engage so, but in a valid contract. It has to be proper valid contract. Okay. So here also a couple of interesting practical aspects we might come across. As I was saying about a holding and subsidiary company, where the management, majority of the management or holding is same. So let's say a person of holding company providing certain processing services of subsidiary or vice versa. Merely by relation, I can't say that, okay, I'm more free to do those. So no, you have to be having a proper valid contract to perform any such act. And this is one such area where we can pick up in terms of drafting contract for data processing. When I say, as again, processing, just to throw light on that, it includes every journey, every phase of data journey. Okay. And he has to ensure a complete and accurate, consistent data which affects the decision of DP. If I'm saying that if I'm processing some data and I'm maintaining certain data, and by processing or by sharing or probably dealing with the data, it has an impact on the decision making of the DP. Or if I have to share with any particular data fiduciary, joint data fiduciary I was mentioning about, it is the responsibility or it's the obligation of data fiduciary to maintain a complete, accurate, and consistent data. Now, this clause also comes on the duty of the DP in terms of whenever he's providing data, he has to be clear and all. So that we'll see once we get into that particular provision. Shall implement appropriate technical and organizational measures. Okay. Now, this is not just about governance, it's about the controls, which is also our risk management scope, what we perform in internal audit. We need to ensure that there is a proper technical and organizational measures implemented by the data fiduciary. When I say organizational measures or technical measures, that is in line with this particular act, that is, which is satisfying the provisions of various sections like section 5, 6, 7, 8 and all, is being taken care the particular entity. Shall protect personal data under his or data processor. So I'm responsible as a data fiduciary. It's not just about the data, what is with me. Even if I have given this the particular data to the data processor, it equally becomes my responsibility. Also, to ensure that there are reasonable security safeguards. Now, reasonable security safeguards is again referred to in section in your IT Act. You can visit IT Act to understand what exactly is the reasonable security safeguards. I believe in rules also it is defined. Unfortunately, though section 43 has been removed, you can still refer to understand what exactly is the reasonable security safeguard. And intimate data protection board of any personal data breach. Now we have this in your RBI or SEBI master circular also notification with regard to cyber security, where they say they need to intimate within 6 hours of an incident, something like that. Though they have not defined any time as of now within the act, they might come across down the lane. But as of now, I need to intimate. This is my obligation as a data fiduciary to intimate the DPBI with regard to any personal data breach. And unless necessary under any law, erase the personal data of DP on consent withdrawal or on purpose is served. Okay, so unless there is a requirement of law, if a DP has given a consent for withdrawal or the purpose for which, as I was mentioning about a marathon example, let's say company has accepted details from a person participating in a marathon. Once the marathon is over, there is no purpose of retaining the data, that is the processing. So obviously, it's my obligation to erase the data and intimate the DPs regarding the erasure of data, either with me or the data provider, that is the event manager who is handling that particular marathon. Now, in addition, apart from these, I've listed the most important as these 7 points. Apart from that, again, section 7.8 also covers about it shall provide information of DPO, especially when it comes to those specified data fiduciaries who has engaged. It's a mandatory to have a DPO. So it shall provide an additional information of DPO, the grievance redressal mechanism, and if there is no communication from DP, it will be presumed she has not approached. That means if there is an ideal time saying that in a particular period, DP has never approached me, in that period, if I am performing any processing, that means it will not be considered as illegal, because that particular act of no communication from DP will be presumed as the DP has never approached the data fiduciary for processing that personal data. Okay, so it somewhere indirectly mentions about the timestamps of communications from DP to the data fiduciary, stamp of communications of consent, timestamp of communication of withdrawal, or for that matter, any that. I need to have a proper mechanism, as I mentioned earlier, one of those technical measures which proves that there was an approach of data principal to process, or there was no approach whatever. Now, we are moving to the second phase from the chapter 2 to the next chapter, that is the rights and duties of data principal. There are these 5 sections which are listed down. 4 are the rights of data principal, and other are the duties. Okay. Now, this particular section is interesting because if there is a failure on the data principal part to perform the duty, he is also being penalized for up to rupees 10,000 by virtue of schedule, which we'll see later. Okay. Now, what are the rights they have, data principal? Right to access, right to correction and erasure. Now, again, a couple of people, the data professionals, expressed a doubt whether this can be considered as a right to forget and all, but right to forget is more global term or more technical term when it comes to erasure, which is actually at the transaction level, if you have to be at my level, if I have to mention that. So right to correction and erasure with regard to that particular personal data which I have shared for a particular process, right of grievance redressal, and right to nominate. Again, right to nominate is one more important aspect, especially when we try to go for litigation or claim something in case of demise or whatever it is there. So these are the rights what a data principal has. These are the 4 rights which a data principal has. This is one of the features what ministry has mentioned while publishing this particular draft bill. Now, apart from that, there is again the duty. That means equal kind of discipline is expected from the data principal also. Just because I've thrown my data everywhere through social media or through various forms, and I come back saying that the data fiduciary has not complied with the act, he has misutilized my data. So no, I have to take care of my duties. That is what exactly is my importance of my personal data, how I am taking care of data, how I'm giving importance to that personal data, how I'm sharing that personal data, what are the ways I'm communicating with all these things. It becomes part of my duty also. Okay. There, one more interesting is duty not to impersonate another person while providing personal data. Okay. This is another feature. I believe many of you would have come across this one. Your spouse might be carrying a mobile number which is actually taken by you because you are allowed to have 5 SIMs. So if in case you have taken a SIM in your name through your Aadhaar card and all, now that number is being shared with your spouse, and she ultimately uses that in the part of request for consent, whatever it is there, saying that no, this is our information and all. So if in case any litigation happens, this might be a point of concern, because that is not actually a identifier or related to identification related to data principle. Okay, so owner is someone different, whereas because when I say identity, it has to be authentic. Various provisions we have seen earlier also in terms of authentication of the personal data, identify personal data identification. So that is one challenge what we need to consider, because that's a duty of data principal. What kind of authentic data I can use, and due to not to suppress. This is sorry for that typographic. It's a duty to not suppress any material information related to her identity. Okay, if I'm giving partly information or part wrong information, or I'm trying to hide something, especially when it comes to health issues or whatever it is, the processing of health data and all. So that will be again considered as your penalty of up to 10,000 under schedule. Now, do not register false grievance or complaint. Again, though it's onus of data fiduciary to prove that he has sent a request for consent or a consent, but ultimately when it's a grievance redressal or any litigation, it ultimately falls back to the data principal to perform his duty, not to provide a false grievance or complaint. Okay, so this comes along with the other legal provisions of any other act. Okay, so to comply with any other applicable laws when it comes to the duties and all. and duty to furnish only such authentic information which is verifiable while exercising right to correction or erasure. Okay. So let's say I have taking the example of marathon. Let's say I've uploaded my interest of participating in a marathon, and I've given certain mobile number and all as my identity. And later on, after the event is over, I want to withdraw my consent, or I want to make a correction or erase or whatever it is. I need to give the same kind of authentic information which can be verified as an identity, my identity. Then only that is my duty. Okay, to ensure that my information what I'm providing, especially when it comes to the correction clause and eraser clause, that has to be properly authentic information which can be authenticated through a verification process. Now moving further, we are of course the last part of provisions, because the rest of all again falling into your code and all, which I am not touching upon. Processing of personal data outside India, which is again under section 16, when it's related to only for the goods or services in India, as I was mentioning applicability, but a specific provision under section 16 with regard to the cross-border has been provided, where they are listing those countries where the transfer is not permitted. Okay, I believe unlike GDPR, which is much more detailed when it comes to cross-border, unlike GDPR, this particular act provides a restriction or so-called blacklisted countries kind of thing, saying that no, to these countries you cannot share, transfer the data, or process the data. Okay, if I have to throw light on GDPR, maybe you have a whitelist kind of thing, or permitted or restricted kind of transfers are permitted cross-border and all. But here it is pretty clear, saying that no, these countries, if they list down by notification to that countries, you cannot transfer your personal data by a data fiduciary. Okay. Now section 17, this is an exemption. This is one of the interesting section for that matter, that the government is going to face much pressure under this section from various organizations or large bodies, because no one want to comply with these kind of rigid sections. So obviously they might approach government of India to consider their board or body to be part of this particular section, especially second section, which says about where it is permitted by central government to be exempted. Okay. Now, obligations of data fiduciary in relation to processing of personal data mentioned in chapter 2, which you have covered, except for 8.1. 8.1 is abiding with the law, and 8.5 is with regard to protection of data, ensuring reasonable steps with regard to the protection of data, except for those. And section 16, when it comes to cross-border, these are all exempted in the following cases. When it is exempted, if it is necessary for enforcing any legal right or claim by any court or tribunal, as we have seen also in earlier kind of obligations, for the purpose of prevention, detection, investigation, or prosecution of any offense. If it is related to processing in India in relation to contract entered outside India, of course, if the DP, if a contract is being entered outside India with a person with respect to DP outside India, I mean, I believe I mentioned it wrongly. Actually, it is a contract entered outside India with a person outside India with regard to a DP. Then that processing will not be considered as part of this, so that will be exempted. Okay. Now, as part of the scheme of compromise or arrangement or merger and amalgamation of a single company as part of restructuring or as part of amalgamation, so and so and so, obviously, the ownership transfer, kind of a slump sale or whatever it may be. So as along with that, the right of data fiduciaries in terms of processing a data based on consents, of course, will move along with the same scheme of arrangements, what it is. So that's the reason they have provided this exemption. And these are the exemptions which specifically exempts, except for those 3 clauses, from rest of all provisions of this particular chapter 2. That is the obligations of data fiduciary. Now, except for those 3 clauses, especially 16 and 8.5, rest of all are exempted with regard to the obligations of data fiduciary in terms of these aspects. Now, as part of for ascertaining financial information, assets and liability, especially when there is a default, a financial institution is also exempted for ascertaining the financial information, assets and liabilities of a person. So they are exempted to process the data without following section 5, 6 or so and so in terms of consent and all that. Along with that, state government, central government are exempted. Exemption from certain provisions. This is where I was mentioning about the last part. exemption from certain provisions to data fiduciary, including startups, by special notification of central government. Let's assume body like ICA has approached central government saying that, okay, it's very difficult, the kind of data what we process or the kind of mechanism what we have, but saying so I may not be in support personally, but they might approach something like that, or advocates might approach saying that they can't be considered as part of that. So that's this particular section exempts them from that particular process of, except of course those 3 sections, which obviously I need to comply, and 8.5 is very much important. Still, no matter I'm exempted or not, I need to have those reasonable security measures. Now we have directly jumped from, because as I mentioned, the rest of all sections in terms of is forming of board, the chairman, how many number of members, what is the importance of person with a specialized knowledge in law, and how they are like section 32, 33 in terms of penalty, or section 28 saying that what is voluntary aspect and all when it comes to data processing and all. So that is again the role of board, which has been provided in those sections. So we will not touch upon those sections. We'll directly jump to the last part. Of course, couple of sections you can go through is the importance of whenever there is a conflict, the importance of this act, which is prevailing over the above act. And this act should be read with other acts when it comes to the especially information technology and all that. So those are also covered in that. And they have given, they've made certain modifications by virtue of this act, the last part, section 42 or 41, 42, saying that no, these because of these amendments, because of this act, the amendments will happen. Okay. Now let's go to the schedule of penalties. Now this is where a very important slide when it comes to penalties. Now, these are the sections which we have discussed. Just to go back of that particular sections which we are trying to discuss, just to throw right on that. Section 8. So one is shall protect personal data under his or data processor control with reasonable security safeguards. Okay, so this is section 5 and this is section 7. 8.5, clause 8.5 and 8.7. No, these are the 2 important. When it comes to 8.5, they have mentioned up to 250 crores, and 8.7 they have mentioned up to 200 crores. Okay, so I suggest you go through this section 8 thoroughly and also link up with the schedule which speaks about the penalty. Okay, so breach in observing the obligation of data fiduciary to take reasonable security safeguards to prevent personal data breach, that is 8.5, up to 250 crores. And breach in observing the obligation to give board or affected data principal, that is, if there is a personal data breach, if that obligation is not complied with, then again the penalty is up to 200 crores. And if it is related to the data of children, okay, this again, this section I haven't touched upon, especially with this is one specialty of this section, unlike in GDPR, where they have given special focus on the children through this act. Again, defining children is one who is up to 18 years of age. So there, if any breach of this thing, this is very important for the reason that if you go to that particular section of children, who I have not covered here, it speaks about the monitoring activities of a child. All these will be considered as illegitimate purposes. So if I'm performing any such act without a consent of a parent or legal guardian, so thus there will be a penalty up to 200 crores. So section 9, you can refer to this. As I said, now avoided considering our scope of internal audit and all as of now, at least for this particular session. Now, breach in observance of additional obligations of significant data fiduciary. This is one section 10 of significant data fiduciary. If a central government notifies any of any data fiduciary or any of data fiduciaries registered, they might consider it as a significant data fiduciary. And the importance of significant data fiduciary is they have specified a couple of roles like DPO. They need to perform a impact assessment. They need to have a periodic audit, or they need to have a regular audit kind of thing. Okay, so there is a proper monitoring mechanism with regard to significant data fiduciary. Of course, they might notify that is they have given what are the parameters based on which significant data fiduciary is considered, like sensitivity of data, the kind of data what they are dealing with. So based on that, they might consider that data fiduciary as a significant data fiduciary. So if in case there is a breach by such significant data fiduciary, you have up to 150 crores. Now I suggest the section 10 also to in terms of keeping in interest the opportunities what we as chartered accountants might have is one this area, whichever company has been notified as a significant data fiduciary. I believe it has at least 8 to 10 different roles to offer in this particular act to perform either job or any kind of engagements. Okay. Now, breach in observance of the duties by DPR. This is what specifically chapter 3, which we referred earlier. That is the duties of from section 11 to 15, what we have come across earlier. The duties of data principal. If the data principal is not complying with the duties, that is impersonating or giving improper information or not complying with any of the provisions of law, so and so, then under section 15, that is the duties of DP, there will be a penalty up to 10,000. Okay, so this one aspect, this also might might keep both the consent manager or so-called DPOs busy to see that how they can challenge whenever such issue comes up. So this is one area what we can think of. So this opens up a scope in many ways because every data owner, if he is not, they need to understand the importance. And that is where the awareness of this particular act is very much required about the bodies like ICA and also in general, the kind of awareness what it is required. Now, a breach of any voluntary term, this I was mentioning about under section 28. This was mentioned in 32, but with regard to proceedings under section 28 by the board, there interestingly they have not specified, but they are having a discretionary power depending on the impact of such non-compliance or the weightage of such non-compliance in terms of how many times they have not complied or all those aspects. They defined a couple of rules in that. Based on that, still no matter whatever rules may say, again it's the discretion of the board to decide upon what is the penalty, to what extent out of the above penalties they have mentioned, to what proportion a DF might be penalized. Okay. Now, breach of any other provisions of this act or the rules made there. This is one very typical provision because if not specified in any of the 6 sections above, if any of that, let's say speaking about section 5, where I have not given a proper request for consent, or section 6, the consent is not in a proper mechanism, proper form, or all that, there is always a chance of attracting this particular penal provision, which is up to 50 crores. Okay. So you can see the kind of the magnitude of penalties what this particular act is throwing up, and that throws one side the opportunities for members, and also another side the responsibility what we have to take up in educating the clients, data fiduciaries, or for that matter in general the society, the importance of this particular act. Now all these sums realized through penalties will be credited to the Consolidated Fund of India. So as we all know, Consolidated Fund of India, that's where all your taxes lies in, and that's where the government expense, from which again they can't withdraw from this particular fund unless there is a parliament approval and all. So all these funds are going to lie into your Consolidated Fund of India. Now, till this part, we have covered upon the important provisions of this. Why I spent more time on this is unless I understand the magnitude of this law, understand, as I said, given time, it's very difficult to push through the entire intention or essence of the act. But wherever I could, I try to give focus. If you can just read such a small act one or twice, you at least get in the aspect of this particular. Now, moving ahead, let's move on to the role of the internal audit and what this particular act is going to have an impact. Now, based on, of course, our SIA, the actual background of SIA, an internal audit is an independent management function which involves a continuous and critical appraisal of the functioning of an entity with a view to suggest improvements thereto and add value to and strengthen the overall governance mechanism of the entity, including the entity's strategic risk management and internal control system. Now, this is the role what an internal audit is expected of by any client or any person engaging us as an internal audit. Okay. Now you can relate this with all that what we have gone through, the provisions of DPDPA, saying when we speak about the obligation of data fiduciary, I need to have obviously take care of whether that is in line with the overall governance mechanism of the entity, is in line with the technical and organizational measures what DPDP has suggested with, or whether the appraisal system or the mechanism, grievance mechanism, or for that matter, consent mechanism, all these are proper. The management function is proper. So that is where the opportunities along with the kind of risk what we have to be prepared with. Okay, enormous opportunities are there, no matter, no doubt in that. But at the same time, it throws so much of challenge. What is the challenge? Let's go to the next slide and understand what is exactly the challenge what I'm speaking about. Now, when I perform an internal audit, there again will be two aspects. One, as I'm doing internal audit as part of my company, wherein I'm employed as an employee in the internal audit department, that is nothing but your contract of service, or similar to the one example what I mentioned, where holding company or internal auditor as part of department, internal audit department is performing internal audit of a subsidiary company or vice versa. Now here, when I perform that role, like especially you have this kind of setup in your banks, insurance regulatory, insurance companies, where they hardly have outsiders. It will be an internal person. But when you are into that role, so it becomes your equal responsibility as a data fiduciary, because now you are a joint audit data fiduciary along with the management. So you have to comply with section 5, 6, 7, all the chapter 2. The obligations of data fiduciary will fall onto you, and you need to recollect the kind of schedule what you have gone through in terms of penalties. Okay, so you have to be utmost cautious in not just drafting. When I say drafting, again, never think that my cybersecurity framework or my IS audit, IS policy, IS framework is competent enough to take care of data protection. Now, as I was mentioning earlier, this thing is something different, which is to be complied at the transaction level when it comes to the data of a data principal. I also need to ensure that I have a proper table of consents. I need to ensure that when a consent is expiring, when it is being withdrawn, when a request for erasure is there, all that at the transaction level, I need to have a proper monitoring mechanism. And that makes my role as a joint data fiduciary more typical. So if you are an employee in an internal audit department of any organization, as a joint data fiduciary, first thing is, no matter whether you are internal part of a company or external, first thing is get acquainted with this particular act. Of course, I've listed down the do's or the important things, to-do list kind of thing for all of us. But it's a time now that fortunately they haven't notified the date. Don't need to wait for the date and all, because now that the act has come into force, it's just a matter of time till the date is notified. So you need to go perform the impact study, perform a gap analysis if you are already having a framework, and then come out with the solutions to comply with the provisions of this act. So that is the responsibility for you if you are part of the internal audit department as an employee of a data fiduciary. Now, second role is as a part of an engagement, audit engagement. They have appointed me as an internal auditor as under the provisions of Companies Act or various, whatever may be the provisions. I'm there to perform an audit, whether it is an internal audit, statutory audit, or for that matter, any kind of audit, wherever I'm dealing with the information or the data or whatever it is there. Ultimately, I need to comply with the provisions of this act as a data processor, because we understood the definition of processor or the data process, especially where it says data processor. Of course, I'll be facilitating the data fiduciary. I'll be helping out the data fiduciary for the processing. But the processing definition, as I was mentioning earlier, also repeating again and again, the journey of a data right from initiation till its erasure or whatever it is, till its deletion, the whatever phase, the data, if it is lying with you, it becomes very important for us as an internal auditor to take care of a couple of aspects. What are those important aspects? Of course, I'll mention that in later stage, but one important aspect is being a data processor. I have also taken up certain important obligations of this particular act, saying security, because though you might say data fiduciary, it's his obligation under section 8.5 or 8.6 and all to see that data is there. But ultimately, if he is penalized, obviously indemnity will make him collect from you also, is it not? So you have to be very careful if you are an external person, more so because as I list down a later stage, the kind of sampling we do, the audit evidences what we collect, especially it includes if I'm performing a GST reconciliation, I might have the 2A data or the purchase data with me, and if I'm carrying that data with me, the consent only the organization is exempted under a particular section in terms of transactional data. But I am not, as a data processor, I am not. Is it not? So I have to be very careful saying that, no, what are those things I need to take care to ensure that I am not complying with these particular provisions. Okay. So as a data processor, reviewing the information or data while forming an opinion based on such review for the purpose of management is data processing on behalf of data fiduciary, obviously. Okay. As an example, internal audit function by an external auditor, that is nothing but your contract for service. Okay. So these two aspects both are challenging in its own way. One as part of your fiduciary, other one taking up the process, which is more even sensitive because you will be carrying the data or storing the data at your own offices. That is where it will be this act becomes very important for us. This already we have dealt with. Let me just go to the practical issues. And this is where I was mentioning about the importance of this particular act for us. Now, when we perform an audit or analytical procedure under 500 series or 520 or whatever, when we do this, obviously we will access the personal data. We need to collect that as in my audit evidence. I'll be copying that. I'll be sending that through mail to my staff, my office, whatever. So we are doing so many things, which if you sit now and see the impact of this act on your own activities as an internal auditor, you might see so many challenges which you have to overcome, which that is where first thing is perform this impact on your own, on your office, on your role, on your staff, see the impact so that you'll get acquainted with the act and analyze the impact of that at your level. And if it at your level, if it is so, what it could be at the data fiduciary or your client level. Okay. So this is one important aspect you need to consider. There again, as I mentioned, I'm not sure how it is going to turn up once it is notified from that particular date. I believe another case also I've mentioned in the last part. Couple of people, they follow the illegitimate practices such as holding digital signatures of client in their office as a key bunch kind of thing, and they upload various regulatory information on behalf of my client. Okay, I file ITR or I apply on behalf of some claims kind of thing, or I do all such facilitation center. If I'm doing that, including providing email IDs, probably you would have sometimes you would have come across situation where if the OTP is not generated at the midnight, I would have given one staff mobile number to generate an OTP, or if a communication is not being received, I might have given some email ID created then and there. All these are illegitimate practices, and more so when it comes to this particular act, because you should see the magnum of penalties what this act is speaking about, and that's where you have to be very careful at your level and also while you're educating your clients. Okay, so these are the few things, and of course coming to NOCLAR, funny ways, funny quote I remember whenever I see NOCLAR, when I go through the schedule of penalties is NOCLAR, as you'll know, applicable to under section 260 and 360 of your code of ethics. Listed companies which is having a net worth of 250 crores. Okay, so I sometimes find funny 250 crores. If I'm not complying, the entire 250 crore net worth is eroded by this particular penalty of DPDPA. Okay, of course, on the lighter side, I'm saying, but you have to be cautious because it's a responsibility of a professional accountant, not just an internal audit, not as a statutory audit, whatever may be the role. If you are defined under professional accountants, it becomes your responsibility to report on the activities. When I say activities, unlike any other regulations, which I might say, okay, that hasn't come in between my scope or haven't touched upon, data protection, which you can't avoid. It is going under your nose while you are performing your audit. And if you identify that data fiduciary has not complied with the importance of consent, request for consent, or obligations of data fiduciary, then obviously it's your responsibility to notify, report that as part of your section 260 and 360. If not, you are attracting the disciplinary aspects, one. Second, you're also attracting the penal provisions of this act. This is where both as in role of internal audit, because professional accountants, as I mentioned, or outside, you have to be careful. This act is going to be more challenging. It's just a beginning of a journey. We can see many issues coming up once date is notified or the various notifications are being issued. Another aspect, leaving apart the internal audit, leaving apart the auditor role. If I take up other role, which as a management consultant, if I'm performing, let's say payroll processing, filing of ITRs of clients, filing of GST returns, where we are accessing personal data of client vendors, providing other management such as services, such as I might provide a dashboard saying that no, I have a Tally remote access provided by my client, and I'm generating a dashboard out of it, or I've been provided with Google Sheets or whatever data of a company, a data fiduciary especially. I'm generating dashboards or MAS out of it and providing as a management consultancy services. And that is again attracts so much of responsibility as a data processor for you. Okay, so these are all services what we are mentioning. It's purely attracting the definition of data processor. Another aspect, financial statement. I remember a practical issues when we were performing forensic audit and all. A narration capturing a personal detail of a particular transaction. Let's say they would have mentioned to a particular reimbursement of certain amount. They would have mentioned the name, mobile number, so and so, so and so. Or for that matter, if I'm dealing with let's say any organization which is accepting membership, any association of person and all. So they use narration part to capture all that information of a member, his mobile number, email ID, his ID, so and so, so and so, so and so. Now, narration is more unstructured, is it not? At least if you are structured, you can say, okay, whether there is a consent, whether there is a request for consent, when is the purpose, what is the purpose of that, what is the deadline for completion, all that you have at least some track. But if you are coming across situation where you are handling the personal financial statement preparation services, where the client has given the entire account ledgers to you, and within that ledger, you are having such kind of issues where narrations and all unstructured way, they have captured somewhere. I've come across the card payment details, also captured the card number, all those details. Even otherwise, if I'm performing FMCG audit, you would have come across that they share the details of card payment and all. You'll have the customer name, his mobile number, his card details, payment debit date, also so and so, so and so. Now, as a processor, even more responsible, even more, because not just forget about the PCA standards and all, but otherwise also under IT Act as well as in this Act, we are tracking so many provisions. Okay. Another area is industry specific. Banking or fintech has its own challenges because the kind of Magnus big data what they handle in terms of customer, because every detail, like say you would have performed a bank audit, what kind of information what you get as a master file, you would have requested saying that, okay, whatever accounts opened during this particular year, you provide me those details along with the loans and also so and so, so and so, which carries very much ample personal data, which is attracting the provisions of this section 2. Then the responsibility as a data processor, because even if I'm performing a statutory auditor, I'm a data processor when it comes to this particular activity. Then what is the challenge? Educational, more and more challenging, because you have to deal with the age criteria also, children falling under 18 years. Okay, their data you are processing, assuming you are performing an audit of educational institution, internal audit of educational institution. The kind of additional responsibility by virtue of section 10 and all. So those things you have to consider, section 9. And hospitals, okay, where not only because health records are not only covered under this Act, it is also covered under IT Act, okay, Information Technology Act. So you have to be very careful. Of course, if you are a MNC company, then you have HIPAA regulations and all that aspects. But I'm saying, if it is industry, depending on what kind of industry you are providing your services, you have to have more detailed study about this Act, more and more what you call detailed checklist about compliance of this Act, more and more responsible it should be compared to any other thing. So likewise, real estate also come across people capturing the persons who have purchased certain plots or flats and all. They would have captured the personal details, obviously for the sake of generating an agreement of sale or whatever. But definitely the data is there in the database, and I'm performing an internal audit of that particular real estate company. FMCG, advertising, event management, more and more industries. As and you keep on touching upon any of the industries, more and more challenging it becomes for you as an internal auditor or as an external auditor. Another area I remember being part of those groups is what if I'm being provided with a peer review or a quality review of any particular firm. Now there is a triparty. Institute is there, I am there, and the data principal is there. Firm is a data principal to which I'm performing a peer review. I'm as a peer reviewer, I'm performing an audit, there is an issue. Now, in those cases, what are those additional challenges I have to take care or consider under the provisions of this act? This is another challenging area. So you have to be very minute. As I said, this act is pretty small. Spend a quality time on this act, understand each provisions, list down as on date, because as I said, the date might not be notified anytime. Before it gets notified to your clients or to all those engagement what you're performing, list down, identify what is that, what is the data, what is the personal data out of it, whom I should be identifying as a data principal, what is my role as a joint data fiduciary or a data processor, who are all joint data fiduciaries of the client. Okay, so you list down. Then after that, whether to whom all I need to comply with section 5, that is request for consent, to what is the format of that, whether the company is already drafted that, whether it is their part of the standards. Okay, so these are the things which we still have time, though of course it's too late. We can't consider it as late, but more and more you're delaying, more and more challenging it is you're making it yourself. Okay. Now, what are the to-do list as a professional? I've just mentioned professional because it applies to internal audit, external audit, any kind of professional accountant, management consultant, whatever. Be thorough with the concepts of this personal data. That is concept of personal data. When I say personal data, especially the definition, the terms, the duties and all, then get acquainted with the provisions of this particular act. Okay. Second thing is, we have performed this impact study by GST Act has been introduced, where we have provided services to the client saying that what is the impact of GST Act on the financial model, where exactly what is the cost which is going to go up, what is the cost which is going to go down, or whatever it is that we have performed that impact study, isn't it? Similar way, you need to perform the impact assessment or impact study of the existing clients in line with this particular bill, saying that what is the impact, what it is going to have in terms of changing the standards or adopting the standards, or organizing the technology or organizing the measures in such a way that I comply with this particular act as a data fiduciary or as a data processor, either way. Now, for significant data fiduciaries, as I was mentioning about earlier, section 10, which will be notified by the central government saying that overall will be considered as significant data fiduciary. For example, if I have to say, of course, I'm just taking a vague example, maybe civil or such companies which actually deals with a couple of processing of data, considering the magnitude of data, they might notify it as a significant data fiduciary. Now, in that case, those significant data fiduciary need to have a DPO, data processing officer, who need to address or what you call the significant data fiduciary related aspects under section 10, and also need to be considered as part of your request for consent, where you need to provide who is the DPO and all that. Now, this is independent data auditor, and again, this will be part of your opportunities, what I mentioned later also. This is one such opportunity what you can pick up. Okay, so if in case, let's say you are part of one particular company where on 1st of September, you are still continuing your engagement of audit, and on that particular date, this act has been notified along with a notification saying that no, these are all are significant data fiduciary, and by chance the entity which you are performing an audit is part of that significant data fiduciary, then what additionally apart from those, you need to see all these compliances of section 10 as well. Now, ensure for implementation of personal data protection. I mean, see, every organization now that you have IRDA, SEBI, what you call RBI, various regulators notifying the standards, what especially when it comes to information security or cyber security, they have come up with standards saying that the company has to follow this structure. Like if you see the concept paper released by SEBI, where they said a company should follow a NIST framework prior to amendment, of course, prior to including governance and all. But they said, okay, these are the things which you need to comply with. Now, like that, every regulator has come up with standards. Likewise, this particular act also requires standards which need to comply with consent mechanism, grievance redressal mechanism, or data protection mechanism, which is different from, of course, the cyber security. So here, I'll take a privilege of referring to one Mr. Vijay Shankar Bangalore Navi, we fondly call him as Navi, who has formed this body, Foundation of Data Protection Professionals in India, where he has developed a very good personal data protection standards of India. I believe that is one of or the first standards notified in personal data. So entities, till the time you come across, I don't think immediately we might see any standards coming up, but till the time you can have this PDPSA, so-called Personal Data Protection Standards of India, developed by FDPPI, as your standard, because he has covered, because whenever we come across the standards, we discuss about 3-line defines and all that. Okay, management, top level management, middle, so and so, so and so. Also, you might think about where this particular DPO should be sitting in, whether it is middle or top. Unlike that, the standards, PDPSA, what I was mentioning about, they have beautifully elaborated 5 different lines of defense for top, middle, HR, because HR and business altogether have to be a separate, considering the importance of this data protection. So likewise, you can have, if you're interested, probably as an academic person, you can visit this website called FDPPI. Many a source, many a knowledge updation I could take from that particular. So to understand various developments of this. So, okay, that's, I'm saying, as internal auditor, or for that matter, auditor, I need to have not only review, I need to suggest my clients saying that, okay, by following these, at least to an extent, you are automating your process of personal data, or to an extent, your process automating your review mechanism when it comes to compliance of this data protection. And you need to have a various awareness training, not only for your staff, not only for your clients, that is data fiduciary, but as much as at large, because we some or other way have an important role when it comes to creating awareness. We have done this when it comes to GST. Investor awareness sessions are being conducted by institute, or various such, where what you call financial discipline related or banking related awareness. So this is one such act which is very much required the kind of attention from ourselves, or as a regulator from ICA, to see that we conduct various awareness training when it comes to this particular, because it has so much of scope and also requires so much of responsibility, both sides, from data fiduciary and data principal. Now, the last important part, what are the opportunities? Now, this is where I was mentioning about performing an impact assessment of data fiduciary as is basis. One aspect is considering chapter 2, that is obligations of data fiduciary, perform the impact assessment as is, okay, and see what are those improvements, what they have to do. Or if your organization is already having cybersecurity framework or IS standards or whatever it is, perform a gap analysis, because as I said, the difference between this and the data security framework or regular data cybersecurity is something different, because legal aspects I need to take care, the transaction level permissions or consents I need to take care. So this requires altogether a different approach. So that you can do. And another opportunity is a job opportunity, basically, as a data protection officer, because yeah, you might come across advertisements saying that now for this we require certification in some various protection related certificate, courses and all. But understanding this particular act, I believe more than any other this thing, you need to understand the sensitivity of this, understanding the purpose for which this particular act, which I believe as an auditor, traveling through various phases of client, traveling through various aspects of society, we will be in a much better position to study this act or to implement this act, to understand the essence of this act. Okay, so if entities or companies or data fiduciaries can understand that particular, I believe any chartered accountant or any experienced graduate in whatever this thing are equally capable of handling this particular, because this is more about understanding the concept of the personal data and how to ensure that the rights of data principal are taken care, are protected. Okay, so that is one. Second is an independent data auditor, as I was mentioning, when it is under section 10 specified data fiduciary. This is one role which they have made it mandatory to have an independent data auditor. Not only that, they have to perform a data protection impact assessment on a periodic basis. That is the responsibility of data fiduciary again, and engagements to perform periodic audit. This is one. So they have notified these 3 aspects to perform an impact assessment, to have a periodic audit, and to have a regular audit when it comes to as an independent audit. So this is where you can grab the opportunity. And Also, now that we are good with handling representations, litigations, and also fortunately various modifications made in the CA final where they have included constitutional law and all. This also gives a scope where we can handle litigation while appearing before DPPA. Of course, advocates are the right persons to handle, but at least to extent of documenting or drafting or assisting to an extent of drafting those litigation representation letters or whatever, still there is a scope of representing. And consent managers, as I have mentioned earlier, it's a facilitation business. It's a larger model, of course, depending on the entity net worth or the backup what we can have, because it has to be something like a portal, like say, not exactly like IT return preparer and all, but a facilitation which allows you, which manages the consents of data principal and also manages the way it is being communicated to the data fiduciary or the data process. Okay. So these are the various opportunities. And leaving apart all this, what I see is this is a kind of act which has a huge gap of demand and supply in terms of assuming the date is being notified, the kind of situation, the kind of data scattered across various entities, various organizations, the kind of personal data what they're maintaining, it definitely requires some professional to review and come out with an analysis, come out with a reporting, and come out with some MIS which probably mitigate the risk of penalizing under schedule and all. Okay. So with this, I'll end my presentation, and I'll hand it over to the organizers. And I thank you all for being patiently listening to me. Let me stop my presentation and get back to the organizers.
Thank you, sir. Thank you so much for the valuable and very insightful guidance and practical approach that you made us understand on the topic. A few questions that I would first coming to that, when we as chartered accountants in practice handle a lot of data of our clients, do we fall under the definition of data fiduciary?
Obviously, that's what. See, basic thing is, as we go with that, identify what is the data we are having, whether it can be classified as a personal data. Okay, once it is classified as a personal data, when I say personal data, if by let's assume that I'm having a GST number, a PAN number, a name, obviously I'll have more than that also, maybe email ID, mobile number, but definitely I can identify this data with a person, or person is related to this data. So that becomes a personal data. Once I identify a personal data, who is the data principal? That is obviously the owner of that. Now that's where his rights will come into the picture. Once his rights, my obligation. What is my obligation? Whether I've taken his consent to have this data, that is, processing is nothing but having the data also. Whether I have a consent as on the cutoff date. If not, what is the procedure? Request for consent, section 5, then consent, section 6, all that comes into picture. So it's not about, none is exempted as of now, except for those list what they've published. None is exempted. Everyone is will be falling into the data fiduciary, as long as it's not for your domestic or personal purposes. Is it not? So that is it. That is where I'm saying perform your self-assessment, self-impact study. Then that's where you start your journey of performing with others, of others also.
Oh. Another question is, we see various ERPs and cloud-based accounting softwares that our clients use in practice, and various data has been shared on the database management systems or the ERPs.
Yeah.
So, for which consent form and everything has already been filled.
Yeah.
So,
no, see,
as of today, how do we safeguard the data that we have shared? And
see, you are saying about consent form in this format, it's already taken, or you are mentioning about consent form while you are creating sharing the data? I mean,
the data has already been shared.
Yeah. So that means if the data is already existing, that means you have to comply with section 5. That means you have to raise a request for consent, get a request. That's first aspect. Second is the cloud and all will be falling into your data processors, because data fiduciary is the for whom he is maintaining the data. It's for you. So you'll be a data fiduciary because on your behalf he is processing the data. Okay, so that he'll become a data processor. Now it's your responsibility, not only on yourself, to see that the security measures what we are defining under section 8 is also complied by the cloud. So that is where earlier we used to have this right to audit and all that aspect, but it has gone a little beyond. because there it might speak about only data security, but I need to ensure other provisions of this act also be complied by the data processor.
Okay, so I guess that sums up the core or the discussion that you did. It was a very thorough discussion, and kudos to your preparation in a very short span of time, that you could prepare the topic so thoroughly, and each and every section and its analysis was so uh, simplified that our approach towards the management of data has changed. We have standard SOPs or something we have to formulate, so that we as chartered accountants, we don't violate data and make sure that our clients are safe. So on the behalf of board of BIMA and Institute of Chartered Accountants of India, I would like to propose a formal vote of thanks to you for sharing your valuable time and experience to us. Thank you so much, sir.
Thank you. Thank you very much. Thank you. Thank you.